So the case challenging the ATF's ban on bump stocks has once again been rescheduled before the Supreme Court. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to once again uphold our Second Amendment rights, go ahead and hit the like button and subscribe. I also want to give a shout out to one of the main supporters of the channel, which is USCCA. Through your membership, you get training, education, and self-defense and liability protection. So if you carry a firearm, I highly recommend you take a look into USCCA, and I'll put a link to them down in the details section. Also, I want to let you know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, a case challenging the ATF's interpretation of bump stocks as actual machine guns is seeking Supreme Court review and has been rescheduled for conference once again. The case we're going to be talking about is Apashian v. Garland. Now, some quick background on this whole issue, how it arose, and why this case is important, not just for bump stocks, but other ATF actions which violate our Second Amendment rights as well. For many years, the ATF had correctly concluded that the NFA and GCA's definition of the term machine gun does not include devices like bump stocks. However, after the incidents in Las Vegas, the ATF, after being ordered by then President Trump, decided to arbitrarily change the regulatory definition of machine gun so that bump stocks would be considered to actually be machine guns within themselves. This new rule took effect in March of 2019, and therefore under federal law, owners were required to either destroy the devices or to surrender them to the ATF. This change in definition made possessors of bump stocks subject to a punishment of 10 years in prison and or a fine of $250,000 if they failed to either destroy or to surrender the devices. The plaintiff in this case, Mr. Apashian, purchased a slide-fire bump stock before the ATF's final rule was issued, like many other people in the US did. After the ATF's change in the interpretation, he filed a lawsuit against the ATF, which is now seeking review from the Supreme Court. In response, the Biden administration filed their brief to the Supreme Court, arguing that the ATF has appropriately interpreted the term machine gun to encompass devices like bump stocks. The three main arguments the Biden administration makes in their brief is that the petitioner has failed to show a likelihood of success, that there is no division of authority warranting Supreme Court review, and that the question of Chevron deference does not need review. After the Biden administration filed their response, the petitioners filed their reply. In the reply, they argued that the Supreme Court should review this case to determine if Chevron can be waived, if Chevron applies to criminal statutes, and they also argued that the case is well suited to address issues of exceptional importance. Now, if you're not aware of what Chevron deference refers to, Chevron deference is a term coined after the landmark case referring to the doctrine of judicial deference given to administrative actions. Generally, for an agency to be given Chevron deference, the agency's interpretation of an ambiguous statute must be rational or reasonable. So when a statute has an ambiguous term, the agency responsible for enforcing that statute may be able to determine what the term was intended to mean as long as their interpretation is rational or reasonable. In contrast to Chevron deference, there is this other rule called the rule of lenity, which indicates that when dealing with criminal statutory interpretation, a court is required to apply any unclear or ambiguous laws and terms in a way that is most favorable to the people, not the enforcement agency. The interpretation of the definition of a machine gun does involve criminal penalties, and therefore the argument is, in this case, that the rule of lenity would direct courts to interpret that term machine gun in a way that is most favorable to the people, not to the ATF. Now, Apashian was originally set to be distributed to the Supreme Court for conference on December 10th of last year. At that conference, the Supreme Court would consider whether or not they wanted to address this issue of ATF overreach. However, while we were waiting for that conference, the Sixth Circuit issued their ruling in another bump stock case called the GOA v. Garland case. These cases are similar in nature, but arose out of different plaintiffs in different circuit courts. Now, the Sixth Circuit heard that GOA case en banc, but they were unable to reach a majority opinion and instead issued a rare 8-8 deadlocked ruling. This deadlocked ruling in the Sixth Circuit resulted in no precedential appeal court decision, and by default, the lower court's ruling had to be in favor of the ATF, and it was affirmed. Now, after the Sixth Circuit's 8-8 opinion, the Apashian case, which was set for conference, was removed from that conference schedule. This was done likely because of that GOA Sixth Circuit ruling, and subsequent supplemental briefs were submitted to the Supreme Court on why the Sixth Circuit's deadlock decision actually indicates that this issue is ripe for the Supreme Court's review. In response, the plaintiffs in Apashian filed a supplemental brief, and essentially they said not even 16 judges in the Sixth Circuit could agree on this issue. They reached a deadlocked 8-8 opinion, and this really does warrant Supreme Court review. After the Supreme Court pulled the Aposhian case that first time, it was then rescheduled and distributed for conference on January 7th. It has then been pulled and rescheduled once again for January 14th. And of course, in an ever-growing carousel of Supreme Court issues and rescheduling on this case, it was rescheduled once again. Now, right now we're waiting to see when actually it's going to be rescheduled for, but this kind of pulling and rescheduling and pushing it out further and further actually might indicate that the Supreme Court is really considering this case. Now, one good thing and one good sign is that during this time when the Aposhian case was recently set for a conference, another Second Amendment case was also set for conference, and that was the PZ v. New Jersey red flag case. Ultimately, the Supreme Court did hold conference on that PZ case and ended up denying cert. So they decided they didn't want to address that Second Amendment case, but they rescheduled Aposhian and put it on for a later conference, a later date. So this might indicate, again, that they're really considering what they're going to do with this case. And I'm curious also, maybe if there's another reason why they're rescheduling this, and it could be because there are some other things going on right now as well with the ATF. Now, that's because in a case like this, a case like Aposhian does not just impact the ATF's attack on bump stocks, but it could also impact other recent actions that the ATF has taken as well. Recently, there was a bit of drama in kind of the gun community on whether or not rare breed triggers was rated by the ATF and whether or not Big Daddy Unlimited was actually rated as well. Rare breed in the past has had issues with the ATF treating their triggers as actual machine guns, and there was concern that maybe the ATF was going after Big Daddy Unlimited and their WOT trigger as well. Right now, those two triggers are actually part of a lawsuit, a patent lawsuit as well. So there's a lot going on with those, but all those reports ended up being false, and that the owner of Rare Breed came out and said that no, they were never actually rated, and maybe now it looks like that maybe even BDU wasn't rated. But regardless of all that confusion about whether or not XYZ person was rated or not, we know that the ATF is still targeting these triggers, these kind of force reset triggers. They're also targeting solvent traps. They're targeting redefinitions of frames and receivers. They're going to target pistol braces. They were aggressive last year on these issues. They're likely to be aggressive on these issues as well this year, and they might go after other things as well. So we will likely see other ATF issues pop up. And that's why this Aposhian case is really important, because Aposhian, if the Supreme Court took it up and ruled on it, would go a long way to correcting the overreach and attacks of the ATF. It would stop them from just simply changing definitions at their whim and then going after different companies and products and other things that are tied to our Second Amendment rights. So in my opinion, I think this is an important case, and I really hope the Supreme Court does actually set it for conference, consider it, and take it up as well. So if you guys have any questions, go ahead and comment down below, and I'll try to answer the best of my ability. Also, if you guys like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. Again, I cannot thank you guys enough for everybody who's liked, commented, subscribed, who's hit the notification bell, who's shared these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach more people than I could have ever thought and spread this type of Second Amendment information. Again, thank you guys for all of your support. If you don't have a comment in mind, just comment down below that you're coming to fuel the algorithm. And also, if you're a new subscriber or if you're a longtime lurker and you're finally subscribing, go ahead and comment down below that you're a new subscriber, and I will make sure I comment back to you. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by Armed Scholars. The nation will be maintained by Armed Scholars.